Уважаемые коллеги, я предлагаю начать наше.
Ladies and gentlemen, I suggest that we begin. It is my pleasure to welcome you at the discussion of arbitration legislation reform in Russia. It's not a usual format at the forum. Normally we discuss purely legal issues, but we realize that the discussion of the bill drafted by the Ministry of Justice and submitted to the government of Russia pushed us to having this round table. At least 3 times we've had similar sessions to focus on the same subject. Let me introduce the panelists to you, the participants in the discussion. It is an honor for me that all of them could come to participate because each of them is an impressive expert in this area. The first critical and essential list is Vladimir Lysin, Vice President of Russia's Union of Industrialists and Entrepreneurs. The union, together with the Chamber of Commerce and Industry, are behind the reform. They reflect the community's demand for arbitration reform. Next to me is Vice President of the Chamber, Doctor of Law, Vadim Chubarov, whom hopefully will make an impressive contribution to this discussion and will tell us what we have done to implement the reform and explain to us why we have chosen the tools and methods we have chosen. We have Vladimir Kvaley, an attorney, and he's Vice President of ICC Commercial Court of Arbitration and partner of Baker & McKenzie. We also have Andrei Gorlenko from Resnick Gagarin and Partners. The choice of experts was caused by their role, which was very active in drafting proposals which later were included in the bill we'll be discussing today. Let me now move over to the discussion per se. Before I do so, I'd like to make some introductory remarks to think out loud about why the subject came about at all. It came about because society, the government, the nation is interested in the development of alternative ways of dispute resolution. Why? Because that improves investment climate. If organized efficiently, that reduces the judicial load and makes dispute resolution more efficient, which is good for business and good for the government. The reason why this work was done was the presidential task, which was part of the presidential address. And this task was based on the results of a meeting between the Union of Industrialists and Entrepreneurs and the Chamber of Commerce and Industry. That's why I'd like to first give the floor to Vladimir Lysin, Vice President of Russia's Union of Industrialists and Entrepreneurs. Thank you, Elena. And of course, for Russian business, SME, and big business, this system, alternative dispute resolution, is a very good option, alternative to conventional means of dispute resolution. When we go down to this work, we realized that the number of courts is huge. and the courts are pretty often used for purposes other than legal. They are used to assist in building certain schemes, and some courts which look decent, so to say, become engaged, so to say. In other words, they were stuck in a conflict of interests and could not ensure independent administration of justice. We spent 6 or 7 months working hard together with government agencies, and then we realized we had to get down to it. This is what we achieved. Recently, we had a business community meeting in a region. I'm not going to give you the name of the region, it doesn't matter. The reason for the meeting was different, but we had a survey conducted there, asking people whether they had the system of arbitration in their system. They remembered that they had occasional courts, and we asked those who had used the system of arbitration over the past 10 years to raise their hands. There was not a single hand raised. We realize we have the Chamber for Commerce and Industry, and more advanced business comes there, those who know what arbitration is about. But still, that's the status quo we have in the country, especially in the regions. Well, we wanted to achieve several goals. First of all, we wanted to see Russian tribunals more than anything else. We are not very happy about a situation where Russian business goes to London, Stockholm, or other countries. It's not the most sensible thing. Not everyone can afford it. It's not too efficient. Of course, for the tribunals, we'd like them to be Russian. At that time, well, we knew that several hundred such tribunals were being created, and most of them could do nothing but stamp a ready document, and it was absurd to have so many of them. Still, many of you know that, are aware of government organizations which promoted themselves as independent arbitration tribunal, which would issue an award for you in 2 days. Well, from on the one hand, we realized we had to reduce the number of existing tribunals. It was not between about choosing between the white and the black. We just wanted to have efficient tribunals. We realized they had to be independent and reliable, which means that tribunals or arbitration centers working for Lukoil or Gazprom are engaged, and they can't be independent. Sberbank, for example, a highly respected bank, or Gazprom, well, we all are gas consumers, and it creates natural conflict of interests. We know how many depositors Sberbank has, and we don't realize how it is possible to have a case against Sberbank. It is an obvious legal loophole, and of course it has to be taken care of. Those arbitration centers took a long time to be created, but then we realized we had to bring the existing system to an end. It was not efficient. The rules of such centers had to be revised. They had to be very open, and the procedure should be professional. Arbitrator appointment and removal should be the result of a group decision. They had to be open, and the funding should be transparent. What is really important for business community is fast resolution of cases. Of course, appeals or cassations, which are not part of arbitration procedure, can expedite the process, but the process anyway should be professional, and the participants, the parties, should rely on a competent award. The court's trust in the process of arbitration is also important, which makes enforcement a critical component of the system. In my opinion, well, of course, we could not expect a revolutionary breakthrough, but I think that a critical step which could bring a real arbitration system for the business community is something which we can do under the bill. So I'd like to express my gratitude to many of you here for participating in the process. We've had many heated discussions, and I hope that at the end of the day we can boast having something good. Thank you, Vladimir. I have a question, if I may. What is the incentive for business? Why would business choose arbitration over government court? Why do they include an arbitration clause? What is critical for them? Confidentiality, time, skills, what? I've been asked this question many times by many of my colleagues. In terms of significance, number one has to do with the professional level. If you want to be sure that people who will be deciding your case understand the situation very well, they understand how and why you operate, that is significant for business. Number two, maybe as significant as the first one, is the time of case resolution and confidentiality, because as soon as you come to a government court, you may forget about confidentiality to a very large extent. Confidentiality maybe is number three, while the issue of time is critical. Thank you. We have a question from the floor, and we should use a mic by all means. Thank you. Maikov, I'm a lawyer. The system that you're about to create, well, it looks like we have three different types of arbitration centers. The first court is under the Chamber of Commerce and Industry. It's not an independent legal entity. Even the Chamber is a non-profit organization. Then there are for-profit organizations, but they're not independent legal entities. And the third group of arbitration courts are legally independent. They're independent legal entities. My question is this breakdown. Does it mean that some arbitration courts are more independent than others? Why some of them are profit and others non-profit? And my second question, if an arbitration court is an independent legal entity, does it mean something in the context of an arbitration center, arbitration court, which should be created logically for hearing and deciding a case? But actually, in every case, every time, you kind of recreate a court. And I'd like to know what the drafter's logic was. I will be ready to take some of your questions, and will ask Elena to take the rest of your questions. My opinion was that we shouldn't have had special kinds of arbitration courts. We should have had just one kind, without one type, without any privileges. But on the one hand, we already have arbitration organizations with impressive experience. And they kind of convinced us that at a certain stage, you don't want to destroy what has been working well, even though my personal opinion is that we shouldn't have done that. We should have had this same type, just one type. And there's issues of lobbying and protecting your own interests. It's quite a normal phenomenon. And another view is, is for the second question, I think it was an appropriate decision, but why it was made, Elena will probably take that question. I will. It's a complicated question. Let me try to explain to you why we decided to opt for a form of non-profit organization as a legal form for organization which administers disputes. The arbitration tribunal shall be decided for every case on an individual basis. The body which administers the process should be an independent legal entity for non-profit purposes with a limited authority. Because that ensures its transparency and predictability, financial predictability, among many other things. It shows the document turnover and organizational structure. Why was the decision made? It was made based on the 20-year-long liberal regulation, when you could choose what you wanted to create and what you didn't want to create and live without any rules. It led to the situation where Russia has between 1,000 and 2,500 arbitration centers which do anything but arbitration. Let's be honest about it. Some of them are quite professional, quite strong tribunals, but on the other hand, there's a great number of courts which are quite engaged, because what they do, like Vladimir said, they stamp documents in a bar. That's what they do, and they help organizations with schemes where they are quite engaged. They help revise ownership disputes, etc. And that was based on our international experience. I'd like to encourage other speakers to make a contribution, because we'll be talking about international experience anyway. Out of 55% of the countries with arbitration, there's this requirement whereby an arbitration center should be a legal entity, so we did not reinvent a wheel. On the contrary, new arbitration centers are created based on that principle. Now, why was the Chamber, or is the Chamber of Commerce and Industry an exception? Because it's a traditional model which may be found across the globe for such chambers, which were at the very beginning of arbitration process. They know they were not created in Russia. They emerged in other countries, and initially arbitration centers were parts of chambers for commerce and industry. That was how they came about. And that is what we included into the law on Chamber of Commerce and Industry. It's one of their functions. And that explains special regulation as it based on traditions, historic background, and thirdly and significantly, it's based on the fact that this organization has been tested, so to say, tested, and it has proven as a transparent and efficient body. Vadim Vitalyevich probably is in a better position to focus on that, elaborate on that. It is with pleasure that I give the floor to him.
Thank you very much, and indeed I would like to continue. We discussed the Chamber of Trade and Commerce. This is a non-for-profit entity, and indeed this is so. We do exist as non-commercial entities or non-for-profit entities, and we can check for compliance with laws. Today I tried to search for the arbitration courts, and I got as a search result the arbitration court of the city of Moscow. And Mr. Kravtsov knows that you can pay an interest to a lawyer and get some decision. The first arbitration court, I don't know this court, but still, the very name of it is quite telling. The Federal Arbitration Court, which published many interviews apparently taken from Mr. Ivanov, although Mr. Ivanov never gave such interviews. Plus the bailiffs that can be sent by that court, and so on and so forth. So there are many such arbitration entities in Russia. In April 2012, we actually applied to the High Court of Arbitration that something needs to be done about those lower arbitration tribunals, which are sort of like bodies of arbitration, but they are not doing arbitration in the true sense of what is meant by the chambers of commerce. Something where we have ample expertise. So something needs to be done about those other arbitration courts. Our fight with the Federal Arbitration Court, with the involvement of the attorney's office in Moscow, and that fight took 18 months, and we managed to change 2 paragraphs in the statute, and all the violations that they did. For example, creating arbitration courts in every district of Moscow and in St. Petersburg, and awarding judges' robes here and there and that stuff. But it seems that we couldn't overcome that malpractice. And I think that it also had some influence on the normal courts of arbitration. Because the most recent practice says that we have so many fixed number of the proper arbitration courts in Russia. The Russian Union of Entrepreneurs and Industries also helped us to somehow go back to basics, to the basics and fundamentals of arbitration. We suggested our own system of establishing such courts of arbitration, which is a bit different from what is reflected in the draft law. But the final objective, as far as I know, and plus the idea was born with the Russian Union of Industries, but the final objective is the same as we had in mind. Those people who are worried about the fate of the arbitration courts, perhaps you might want to look into the guidelines of the Ministry of Justice, which define where and how such arbitration courts can be established. And the guidelines say that at least 50% stake in such entities should belong to the government. And also the Russian Chamber of Commerce can offer its expertise. We have the Russian Union of Industries includes 50,000 entrepreneurs, and now we have 157 chambers of commerce and trade across the country, including the Crimea. Plus, of course, the guidelines and the procedure has a temporary nature. It just would cover those who hit the first top 10 in a search engine, those who present themselves as arbitration courts, but which are not. About changes in the law. Of course, you read 2 draft laws, but let me remind you about the amendments to the tax legislation. Not an easy question. Of course, when you regulate arbitration every day, then you realize that basically we're saying that this is the attractiveness of having such arbitration entities in place. And the idea is that you provide a service which is regulated. However, this service is not covered by the VAT requirements. I know that there are some concerns that there would be kind of like 2 ways for the draft laws to exist. The tax piece would go its own way, unlike the other 2. But our concern is that by saying that arbitration is a service and we won't have a fixed rate for such a service, and if we don't mention that this is VAT exempt, then we may lose in terms of the advantages of such arbitration courts. The reform itself, and we are thankful to the working group, we're thankful for the fact that during our work, all those deficiencies that we see in national courts of arbitration, which come then to the federal level, and which also draw some negative feedback and critique, we are talking about international non-commercial arbitration. That's why we still have the principle of dualism in arbitration. You know, the law on international commercial arbitration and the national system, but we chose a different system to raise the national arbitration standards, to bring them closer to international arbitration standards, something that we have been doing for 80 years. Here I see some present and retired judges, and really we need to remove this restriction on the judges to become arbitration judges when they retire. And this is something that we have repeatedly discussed at various fora, but we always get the answer that this is not the way for us to take right now. But the arbitration community really would appreciate to have an inflow of such knowledgeable arbiters to come. Vasily Medansky, whom everyone here knows, recalls that he is fond of his work and career both in the court system and in the international commercial arbitration system. And the first place he would go of his choice would be this international commercial arbitration system. And a few other points which I think are quite positive. Let's take a look at the laws about arbitration proceedings, about the eligibility for arbitration. We know that there is a general principle which was reviewed by the Constitutional Court. In May 2011, the Constitutional Court supported arbitration, saying that out of this narrow problem of whether real estate can be eligible for arbitration, we come to discuss a broader concept of arbitration. And I remember that the High Court of Arbitration really asked the question whether the International Commercial Arbitration Court is at all eligible and legal, but the Constitutional Court really denied this claim, saying that this goes beyond the case. But this idea of trying to take away the authority and powers of the arbitration courts piece by piece is still here. Take government procurement. Indeed, we see that arbitration is no longer involved because we're talking about public disputes. And arbitration has nothing to do with government procurement. In Smolensk, we actually have quite a good expertise of cases reviewed by the courts of arbitration, and so on and so forth. And the opposition to having such procurement cases reviewed by the arbitration courts was caused by the fact that some of the arbitration courts produced invalid or improper judgments. Actually, one of the arbitration courts, which was used to decide on disputes in government procurement cases, was directly mentioned in the higher arbitration court decision. And we're talking about an arbitration court which was established under an LLP. Something really, some weird entity, I would say. So coming back to the draft law, you would have very clear focuses on the eligibility for arbitration of particular cases. Some of the disputes should probably be not reviewed by the courts of arbitration, like privatization cases and government procurement cases are probably not also subject to arbitration, but the execution of such procurement contracts, so this could be arbitrated. The parties would come to a court of arbitration saying that this contract is not being complied with, and we need to find a solution. Some of the municipal bodies came to a court of arbitration to find a solution, but the municipalities now are prohibited of applying to the courts of arbitration because some of those arbitration courts charge so much money in fees that municipalities simply cannot afford that. But a good arbitration court would always regulate its fees. The arbitration court would always be approximately at the level of the tariffs charged, fees charged by the public arbitration courts. Now, unless we work harder this time, people would not come back to us for the dispute resolution. So the reform is going on for the privately established arbitration courts. Not easy, but still. Igor Sukhanov mentioned that what they actually proposed was about legal entities, but in terms of the reforms, but they didn't get what they wanted really. But the main sound things are reflected in those draft laws, and we would be supporting that even further. Thank you. Andrei Andreevich, I'd like to ask you to, a bit later if we may, Andrei Andreevich, perhaps you can discuss this with our colleagues in more detail. We do see Mr. Kawamura here. I do see people here from ICC and other important arbitration institutions. They are not probably well versed in the reforms. Perhaps you can tell us about the main ideas and the key points of our proposed reforms. Thank you. I probably would like to discuss in more detail our reforms, the origins of this reform, of what would be the reforms that are proposed and amendments, and how such changes can help find solutions to the challenges that we have discussed so far. First of all, it all began not with any draft laws, but with a set of policies to develop arbitration proceedings. This was done in line with the instructions from the President. The Ministry of Justice developed a set of policies and actions that identified the main challenges that need to be resolved in reforming the arbitration system. There are 6 of them. The first, the lack of uniform legal requirements for the courts of arbitration and the existence of the so-called pocket courts of arbitration, the lack of uniform qualifications and requirements to arbiters, lack of independent single bodies of cooperation and regulation for the courts of arbitration, lapse in regulation of procedural issues of the arbitration courts, etc. And these are the main points that we actually needed to resolve. The draft laws, draft law are actually three of them, no, three sets of them. A new federal law on the courts of arbitration and arbitrage in the Russian Federation. This new law would fully replace the 2002 law, the second law on amendments to individual or single legislative acts of the Russian Federation because of the adoption of this arbitration court federal law. And the third set of changes, changes to parts 1 and 2 of the tax code of the Russian Federation and the federal law on insurance and premiums and contributions to the pension fund. Of course, we pay more attention to this totally new piece of legislation, the federal law on courts of arbitration, which can be viewed in three parts. The first part would regulate the arbitration procedures, and this is totally based on the model law of UNCITRAL, just like it was done in 2003 about international commercial arbitration. Now, the second part would be about the organization and establishment of an arbitration institution. Again, all this is based on foreign best practices and arbitration institutions, and also thinking about any deficiencies of the existing system. And the third part would be some transitional provisions to understand how to come from the existing system to the future system. Perhaps I should begin with, it doesn't work. Next slide, please. The first part about the main changes and amendments to be made to the arbitration procedures. The main changes that deserve attention would be the introduction of single bodies of assistance and control for the purpose of the federal law. Thing is that we missed before the individual functions of control over arbitration procedures. First of all, about the appointment of the composition of the arbitration courts. And the UNCITRAL rules actually require that, and usually this is done by the official government courts in all countries, where you can nominate judges in disputable situations and circumstances. This was missed, indeed, from the law that we have so far. So this law about the arbitration courts should mention the control and assistance to arbitration courts and the administrative code of the code of administrative procedures and the civil code should really mention such changes and amendments.
And another block of issues which was missing had to do with jurisdiction. UNCITRAL model law has a provision whereby you can appeal the issue of jurisdiction with a government court. That provision was missing in the national law, and it was missing in the civil procedure code. Now it was brought back into the law. And so we can say that once again we're promoting unification for that block of issues as well. Now let me speak about arbitrators and the requirements, qualifications requirements that they should meet. An arbitrator can't be younger than 25. can't have limited liability. This person, the arbitrator, can't have conviction which was not expunged or sentence which was not served. An arbitrator can't be a person whose authority was terminated due to the violations incompatible with his or her core activities. The sole arbitrator or the president of the tribunal should have a law degree or legal skills, should have passed bar exam or other professional entrance exam. And if the parties want to invite an arbitrator who is a known lawyer, they may agree to do so if the dispute can so justify. The second block of issues includes the creation of an arbitration center. It has been discussed already. So number one, the center should be a non-profit entity. There is an exception for chambers for commerce and industry. Why? Because it's what they do, and that is prescribed in the law on chambers for commerce and industry. The biggest problem here, the biggest issue is that the arbitration center doesn't have a special legal status, and as a result, you cannot find the arbitration center as such. It becomes like something like a phantom. If you want to disagree with arbitration center, sue the center. After all, it should have a certain status. And of course, you can always find an arbitration center under the Chamber for Commerce and Industry. And there's a set of requirements to be met by the founders. And that gives you the second filter, so to say, the second key. You can create arbitration. Anyone now can create an arbitration center, an individual or an organization or a private company that creates a potential problem of engaged arbitration centers. If an organization may do that, it will be totally engaged, and that makes it difficult to make sure that the court is unbiased and independent. Western colleagues, they don't, if a court arbitration center is created by a private company, it is not viewed as an arbitration center in the West. Now, the founders may include stock exchanges, and there's a certain list of limitations with respect to who can't create arbitration centers, like individuals, government officials, government agencies, political parties, government corporations, bar associations, because somebody used an example of an arbitration center which was part of a smaller firm. It's absurdity. And the second requirement is approval issued by the Ministry of Justice based on the decision made by an interdisciplinary expert council. Let me speak about the council for a minute. It, under the law, it should consist of civil society members and representatives of government agencies. At least 50% of the representatives should represent organizations other than public agencies. The law has criteria which the Council should take into account before they issue an approval. First of all, they should meet the existing rules. They should be guided by the recommended list of arbitrators. The information will be tested and validated. It must be reliable. Arbitration center should promote dissemination of arbitration, development of business ethics. Arbitrators who agree to act as such must be highly respected people to be included into the recommended list. The reputation of the founder should make sure that the arbitration center could operate on a high professional level. Of course, the Union of Industry and Entrepreneurs is an organization which is in a high enough level. And of course, you know that a lot of its members will likely come there. And if you're a successor in rights, you have to carry on with what your predecessor did. The law doesn't require that this arbitration center be a non-for-profit organization. It may be non-for-profit, or it may be a different legal form. You can't establish any limitations. To administer disputes in the Russian Federation, such experts should receive a permit from the Interdisciplinary Expert Council. That is done to avoid offshoreization of arbitration centers, where people who will be unable to create an arbitration center will go offshore, and not necessarily offshore, but to different, more liberal jurisdiction. And will bring their cases there, the jury, and stay here de facto. And there's another specific criterion, such a foreign arbitration center should have an internationally recognized reputation, which means that existing courts of arbitration will be easily registered in the ministry. But if you have a new arbitration center in BVI, it is unlikely to be registered because it doesn't have a generally recognized reputation. The law has requirements for arbitration center organization. There are requirements vis-à-vis the rules. There should be a list of arbitrators, including at least 30 names. Number 3, there should be a team, a special body which will be deciding on who to nominate as arbitrators. The most recent bill says that such issues can be decided by a sole expert, but as a general rule, that should be done by a team to avoid a situation where the lead arbitrator nominates arbitrators and then decides a case. There should be a website on the internet and transparent information about funding. There are some limitations with respect to arbitration centers. Some of them apply to the names. You can't use the name of arbitration court or three-party court if the name is identical to the existing name of the arbitration court. Quite recently we heard news about the creation of a high commercial arbitration court in Crimea, and we had a good laugh because it was presented as something new. Number 2 is take all steps to prevent conflict of interest. An arbitration center where the participants, those whom they control or are controlled, act as party to an arbitration case. If they are members of nominating committee or somebody else, so we want to avoid a situation where the chief arbitrator is legal counsel of the organization which created the court. Now let me speak about the rules of arbitration centers and the standards they have to meet. Well, first of all, there's several possible sets of rules which may be adopted. Arbitration as a system, as an institute, is being developed. You can adopt international arbitration rules, corporate arbitration rules, etc. And according to the law, the arbitration rules should be such that you can easily find information about how the center was created, arbitration center was created, how it operates, and the procedures, arbitration procedures, should be reflected in the rules so that the party could know which procedure to expect as part of the arbitration process. Where the law provides that parties want to have a direct agreement as opposed to making a reference to the rules, like that the lead arbitrator may not have a law degree. That may not be done by the reference to the rules. That should be included in the agreement signed by the parties. So if it's an exception, you can't make reference to the rules. And whatever the rules, they should be published, they should be documented, and the new rules can only apply after they are published, so that the parties are not surprised and don't have to play by the rules they have never heard about. Now, let me speak about ad hoc arbitration centers. China has outruled them, Russia has not. But there were heated discussions. Many believe that limitations should be introduced here to avoid a situation where somebody wants to use ad hoc as a disguise for their dishonest activities. So ad hoc arbitration centers can only take place in existing arbitration institutions. So if you want to have an ad hoc arbitration, you should come to an existing arbitration center, which is allowed to hear cases on the ad hoc principle, like I said, to avoid a situation where you have vague organizations which act as ad hoc arbitration centers. Ad hoc arbitration centers will be allowed to hear any commercial disputes, but the government courts will not be assisting them in obtaining evidence. Now let me speak about arbitration centers' liability and arbitrators' liability. Let me first focus on arbitrators. Of course, they have civil liability immunity with respect to civil case initiated as part of a criminal case. There is no liability for a knowingly erroneous award. However, there's liability for some other violations, and that goes for arbitrators and others, like bribery, assistance in bribery, solicitation of bribery, tampering with the award, and there's civil liability in the form of damages caused to the parties as a result of a failure to administer a dispute. For example, if the arbitration center failed to send a notice, advise somebody of the dispute, lost documents, they could be held liable for that. Another block of issues is arbitrability. The bill introduces the general, very liberal criterion of arbitrability, whereby arbitration has jurisdiction over disputes between parties in a civil dispute or private dispute. There's a list of disputes which are not arbitrable, with reference to specific categories of cases whose administration is defined in the Civil Procedure Code and Administrative Procedure Code. Most corporate disputes are arbitrable, and above all, international, domestic, and external commercial disputes, and there's a list of arbitrability criteria. And another and final significant block includes transitional provisions. Well, above all, the law will become effective on the 1st of January 2015. After it becomes effective, and the creation of new arbitration centers is only possible under the law. Before the 1st of July 2006, we'll have a transition period. And during that period, new arbitration centers should have approval from the minister, from the interdisciplinary expert council to administer disputes based on arbitration agreements, which had arbitration clause mentioning the court which was created before the law became effective, so that this new arbitration center could be perceived as a successor of the existing center. You have to have founders come to the Ministry of Justice and have the Ministry of Justice approve that they are a successor. And those are some basic provisions I wanted to discuss with you. Thank you. Thank you, Andrei. for a detailed overview by the bill. The bill is big. It includes lots of critical details, each of which I believe will become subject of doctorate theses. There's lots of debatable issues related to arbitrability, etc. And we might focus on some of them later as part of Q&A. But before we move over to our discussion, I would like to ask Vladimir Kvaley to speak about the existing reform. As a representative of the international company, he is not happy with every component of this reform. Vladimir, you have the floor, don't be too shy. Thank you, Elena, especially for encouraging me not to be shy. When you read the bill, I'm not sure many of you have read it. You have this controversial impression. A lot of things there are good things, which are extremely appropriate. And yes, the bill is becoming better and better. A lot of legal loopholes are being removed. There's something tainting the bill, but I'll speak about it at the end. Before I do so, let me focus on something positive. Arbitration reform is just one side of the coin. I took a long time thinking about why France, Germany, or the United States of America don't have arbitration court registration system, and they don't have engaged arbitration centers. There's no awards issued retrospectively. There's no violations. When I analyzed that mechanism, I concluded that the arbitration regulation system is a three-leg stool. You remove one leg and the stool falls down. What are they? Leg number one is legislation, of course. And it's also interesting, the countries which are most popular venues of arbitration, none of those countries has a law similar to the UNCITRAL model law, not the UK, not France, not the United States, not Germany. They have their own laws, which are similar in a way to the UNCITRAL model law, but they're different. Model law, UNCITRAL model law, is a standard product for emerging jurisdictions. It's not a sacred cow you want to pray to, because if you feel that you need to change the model law, it's okay. What the Ministry of Justice has been doing is focusing too hard on this first stool leg. The second leg of the stool is the judicial system, of course. And once again, let me make another reference to the UNCITRAL model law. Even though the UNCITRAL model law on commercial arbitration has been excessively successful, and it has been adopted by many countries, it hasn't made arbitration more popular in those countries. And it is not making those countries as a popular venue of arbitration, popular place of arbitration. Why? Because an effective judicial system, the law, is not workable. It's not important at the end of the day what is written in the law. It's important how the judges interpret that. The second leg of the stool is my big concern in the Russian context, because currently the legislative system is based on the legislation. It focuses on the legislation too much and is not focusing on the judicial system enough. Judicial system has a lot of general problems outside the context of arbitration, but as for the context of arbitration, we, and not just we believed that the professional level of courts overseeing arbitration should be improved. The initial bill had cassational courts do that. We wanted this level to go down to the appellate court, and now it's back to the trial court again. There is this problem when judges don't understand very well how arbitration works. It creates a lot of distortions. It would be great for us to bring the initial proposal back and to delegate the function of oversight to the appellate courts.
Well, it won't solve the problem because they need to provide some training to the judges so that the judges would know where to put their attention. And there was another proposal about the foreign arbitration judgments, because the enforcement of such judgments is necessary from the point of view of investment attractiveness of Russia. The idea was to concentrate such control in one court, which is no big problem for Russia. Statistically speaking, the enforcement of foreign arbitration decisions, the number of such is no more than, say, 50 a year, so it can well be concentrated in the hands of one court in Moscow. And this is the practice of many other countries, like in France. The appellate court in Paris would cancel any arbitration decisions. That's just one court that decides on that. The Stockholm appellate court in Stockholm really decides on the same matters. Even in Belarus, the upper economic court of Belarus with panels decide on such matters. But again, the number of cases involving foreign arbitration is not very high. So if we scatter such cases across Russia, we won't have some consistency in decisions, so we'd better concentrate all of them in one court. And then the legal community, the self-regulation of arbitration proceedings, something that is lacking in Russia today. How it works in foreign jurisdictions. Let me give you an example. A couple of years ago in Sweden, the Stockholm appellate court revoked one arbitration decision, and the reason for that was that the arbiter reviewing the case was a partner in a legal firm, and the partner actually was representing the interests of a customer against one of the parties in the arbitration case. A conflict of interest, and that was the ad hoc revocation of arbitration. I know that case quite in detail, and the arbiter was really concerned not that the decision was cancelled, but he was more concerned about his professional responsibility in the bar, because the bar actually automatically invoked some review of the practice of these arbiters. So lawyers have their standards, quite strict ones, and they care about their reputation. And this is something lacking in Russia totally. Most of the legal community is not covered by any professional ethics, but if you take some legal associations, so those ethical principles are quite fragmented. If you take a look at the cases that were invoked for any violation of professional ethics, my impression was that the biggest crime that a lawyer can commit would be not paying fees to a bar. That's the most grievous crime of a lawyer, but I never found any punishment for a conflict of interest. And in the law, it says that the bar associations are prohibited from setting up arbitration courts. Why? Because there's a danger that is seen by some that lawyers would be forming the arbitration courts and manipulating the decisions. So we're not really opposing this negative phenomenon. We need to have some professional associations of lawyers, but they need to be efficient. A lawyer in France would never even think about cooking up an arbitration decision somehow retrospectively, because the biggest responsibility for a lawyer there would be being kicked out of a bar, and the lawyer would only be able to find some alternative employment, but not as a legal professional. And this is something that we need to have in Russia to create a landscape or an environment where some unethical behavior in an arbitration situation would be negatively looked at. So I think that we made the first step with our draft law, and I hope that we would be moving towards a court reform and a reform of the legal profession. Hopefully, like a mosaic, this would all fall into one picture. But something of negative, of course, if you take the arbitration court practices, I mean, if you're talking about Russian arbitration courts, it's not that I was really concerned about this. Some decent arbitration courts would be able to comply with the norms of registration of such courts, but this would not be efficient enough because you would have some bypasses. Some of the corporations are already thinking about how to really set up a non-for-profit entity with an arbitration court attached to it. They would come to the Ministry of Justice to register that. Getting this registration from the Ministry of Justice, they would put it in a frame, hang on the wall, and sign and claim that we are registered by the government, so we are an arbitration court that was registered by the Ministry of Justice, so we are official. So would it be efficient to cure the disease we're talking about, a related problem of foreign arbitration institutions? In April, we had a conference involving representatives of all foreign arbitration institutions. And people came from Stockholm, Berlin, London, Switzerland, from anywhere. And I asked all of them a question: would you like to be registered? And they said, no, we're not going to get registered, with all due respect to the Ministry of Justice. And then I asked, what would you do then? And they said, we'll avoid Russia. So trying to somehow to avoid this bypass of putting business into offshores would probably cause a totally different picture. In Ukraine, when they introduced the registration system of arbitration courts, some people actually set up some really petty arbitration courts abroad also. But the simplest way would be probably to have a list of the arbitration institutions, foreign arbitration institutions, that do not require such domestic registration in Russia. As far as public procurement is concerned, I understand the problem, and indeed some of the arbitration courts are used to legalize indecent procurement schemes. But procurement is done not only inside the country, but there are international tenders held for large procurement projects. Many foreign companies, knowing that disputes with the government companies doing the procurement would be held in arbitration. This would be a red flag for them, and they wouldn't be entering such tenders. I remember a customer who was taking part in a tender in UAE, and he said that the conditions were very bad for the outside contractors, but the only good thing was that arbitration would be done in Moscow. Now, of course, for international procurement, we need to provide an exception. We can do this for domestic procurement deals, but not for any international involvement. I think the big result is that we already have a dialogue between business, the government, and the legal community about reforms. And the reform of arbitration legislation is this dialogue was unique. Even the conference that we had in April involving the Ministry of Justice, the Higher Court of Arbitration, I had a discussion with the representative of the Swiss arbitration chambers, and he told me that, Vladimir, I'm really surprised to witness such a dialogue. In Switzerland, it would have been impossible. So when we talk, I think we can reach the good result. All people sitting here, we all want one thing. We want arbitration to be a mechanism of dispute resolution that would be trusted by business, as would be a win-win situation, because business gets some advantage from that, but the government would also win that, because the government wouldn't mind to have a dispute given to a decent arbitration court. Lawyers would be happy because we would have some money to make. All we need to do is probably get rid of this murky situation in the arbitration system. But you shouldn't believe that tomorrow, as soon as we adopted law, everything would change for the better. But this is the first step. Thank you, Vladimir. I would probably share and your message that there is a need for joint work. Indeed, the position of the ministry was that we need to do it together, and this is in the common interests. And only through joint work can we achieve some good result in reforming a very complicated area, which cannot be strictly described or defined, which would be subject to some discretion, but it would be part of some fiduciary relationships between business, the government, and public courts, because without this is going to be a stool without one leg or another leg, but so nothing good is going to happen from that. So if I may, I can also comment some of the discussion points that you raised. Regarding the eligibility of enforcement, personally speaking, I am also in favor of some specialization of the entities that would be doing the enforcement, but the court system should be prepared for that. It would be the desire and the need of those institutions. Courts currently would not agree with our approach, and the version that we currently discuss, basically status quo, to be preserved. And this is the decision which is prompted by the attitudes of the courts, and the system cannot be really broken by explaining that the courts would only benefit from that. Perhaps this is something for future, which is in line with the changes going on in the court system in general, and whereby we would be changing some procedural matters as well, and we would have to work with the Russian Union of Industrials and Entrepreneurs and the communities on that. As far as this important provision is concerned, really important, and we discussed this at length, maybe 6 hours of discussions on that. First about the open and closed legal services markets, then discussing the future of corporate in-house lawyers. I took part in both roundtables, and indeed we discussed the importance of getting a standard, a benchmark of legal services, and the importance of setting the status of legal profession as an elite one, so that the status of lawyers to a person would be more important than any administrative barriers or sanctions that the government might impose. It's important for the legal landscape to have also very high, good quality legal culture, and this provides for the possibility of customers getting the right services and also trust and confidence in the legal profession. The lawyers must be open, fair, and firm, and in such an environment, the course of arbitration would be easier to operate. First, we need to have a legal norm, and then we need to have some implementation or enforcement norms. And what you mentioned is again a very long process that we went through in not only in perfecting the court system, but also perfecting the legal profession markets, and also thinking about the qualified assistance, as is in line with Article 48 of the federal law, whereby customers have the right to access to good quality services. And this is something that we are discussing in different venues and fora, like this forum. I would probably not repeat the ideas about registration for domestic courts. I think this is something for the transitional period, something that the Commission would be working on. Probably in future we would cancel such a registration requirement. But when today you see almost a pathological situation which brings about some crime in this field, hopefully this is going to be resolved by such requirements. As far as some respected foreign arbitration institutions are concerned, then we actually don't have any requirement for such institutions to be registered. There is a procedure in place, of course, that an institution has to declare its intention to operate in Russia, present your documents, and then you'd get the authority to operate. Some people say that perhaps we should, in the process of adopting the law, we perhaps may think about such a list of the foreign arbitration institutions that do not require registration. Maybe like in the case of the International Commercial Arbitration Court, maybe we would name, say, top 5 that won't require such registration, and even without any application, they would be getting a registration, because we need to have some equal playing field between domestic and foreign arbitration institutions. But for the top 5, for example, we would be issuing them without any application. So basically an authorization to operate would be issued without application. So something of the kind can be found as a solution. International procurements, of course, you're talking about public procurement systems, so this is something that we discussed at length. And if you take contracting or contract disputes, I don't think such disputes, or at least our position is that such disputes have very high public significance to be really subject to arbitration procedures. If you take the execution of a contract, when you basically have equal parties to a contract and there's no more this public political aspect to it, then of course at least we can discuss the involvement of arbitration courts in regulating and controlling the implementation of such contracts.
For international procurement, of course, there are some pros and cons, and we may achieve a compromise. I'm sorry for interrupting you. You can look at it at a different angle. If it is international contracts that we discuss, the Russian party does not have to be respondent. Russia may be a plaintiff. And if we bring this kind of cases to government courts, then the enforcement issue will be big. And that will be detrimental for the national interests of Russia. Government agencies responsible for procurement and signing agreements, they may lose judicial remedy abroad. I agree. Well, colleagues, yes, please. Let me start with what you said last. Gleb Sevestyanov, editor-in-chief of Arbitration Court Journal. We all know that the place of arbitration is a legal fiction. You may have arbitration in Russia and say that the venue is in a different country that takes care of the problem. Not for arbitrability. Like I said, to avoid offshoreization of arbitration, as for corporate disputes, those are arbitral only if they successfully completed some procedures that meet the law requirements. Yeah, let me move over to my question. Before I do that, I'd like to thank this forum and the Ministry of Justice for arranging such an impressive discussion of arbitration reform. I think that probably it makes sense to bring together all alternative dispute resolutions into a single system and have a discussion to focus on this as a single system. It will be easier to show how unique it is. It's my recommendation. I quite agree with Vladimir Kvaley, who described to us a stool with 3 curved legs. I think we might have a 4th leg to enhance the balance. Back in 2009, at the law school of the St. Petersburg University, we had the first conference to address education in the area of alternative dispute resolutions, and we suggested that alternative dispute resolution be included in university curricula. It hasn't been done, but understanding the nature of arbitration or alternative dispute resolution has an impact on anything else, on drafting legislation, judicial practice, arbitration practice, and everything else. If we go back to arbitration reform acts and bills, if we choose to discuss the existing system of monitoring potential violations, currently this monitoring is done at the later stages, at the enforcement and appeal stage. That is one layer of monitoring. What does the legislation tell us? They give us 7 different filters protecting us against violations. That's a very liberal count. It's as many security features as for banknotes, and that brings us to the issue of proportionality. Do we really have to introduce security features, and at what stage, and how many? Of course, our legal community is aware of potential violations, and because of that, there was a proposal to introduce a principle of information transparency for arbitration courts and introduce a system streamlining the naming system so that arbitration courts could get appropriate names, and that could make the fight against potential violations better. The current system under the law can be excessively formalistic, create a lot of delays, and that will affect the trust in arbitration by potential customers or users. Another sad consequence will be a reduction in the number of disputes heard by arbitration centers. We have a lot of people waiting to ask a question. What is your question? Number one is about proportionality. And another question is purely practical. It has to do with the existing bill. If you come to the expert council, you have to meet criteria. And one of the criteria is just an estimate. You have to meet the existing standards. How can you confirm it? Which documents do arbitration courts have to submit with the expert council? These questions have been asked many times. Another question is also purely pragmatic, rhetorical, if I may. There is a special procedure for submitting information about arbitration center. What is the special procedure? Thank you. Andrei, do you want to take the question? Number one, about proportionality or commensurability. The biggest idea was the 7 security features, just like for banknotes. It's okay with me, because every arbitration award is significant. It may lead to billions changing hands, so security features are significant. Somebody may lose assets as a result of an arbitration award. I don't see any problem with that. Your second question was that you have too many overly complicated mechanisms creating lots of delays and resulting in less trust in arbitration. That's on the one hand. And on the other hand, arbitration awards may be issued on day 10, but in the regions no one comes to arbitration centers. What can we lose? Efficiency of arbitration centers in the city of Moscow? Can we lose the trust which is non-existent anyway? What is the specific security feature which you are not happy with? Like Vladimir Khvaley said, he doesn't see any problems. Microphone, that's a problem. Yeah, I've already answered that part of your question. It's okay to lose the trust which doesn't exist. And it's okay not to lose the efficiency which hasn't been developed yet. As a facilitator, I'd like to stop this discussion. I have some comments I'd like to make, but Vladimir just is getting the mic out of my hands very briefly. Yes, there is an element, a subjective element, in the operations of an expert council. We, from the Arbitration Association, have developed some principles that we recommend for arbitration institutions. It's just a project. You may find it on the Arbitration Association's website. It gives best practices of best international arbitration courts. Based on those best practices, we have developed recommendations, not standards, not laws, but recommendations with respect to transparency, relations with the founders, arbitrators' qualifications. It's a 4 or 5 page long document. It's not a guarantee that the expert council will choose to follow the recommendations. They may say that it's just an opinion of one organization, but it's, like I said, a recommendation. Ludmila has a question. I don't have to introduce her. As soon as she starts talking, I feel like I'm a student at an exam. I'm from St. Petersburg University. I was somehow shocked when I read the proposed bill. And at the time, I was shocked when I heard what I have heard today. I understand that we always want to do something good, and we have what we have. When this bill was drafted, did you or did you not take into account the fact that an arbitration court is part of the system of alternative dispute resolutions? So a person, a legal entity, or an individual may choose it to get away from the system of justice. Because an arbitration center, an arbitration tribunal, is not part of the justice system, just like international commercial arbitration. They are not part of the government's judicial system. And because of that, they have to be protected somehow. Arbitration proceedings are not a judicial process. It's not court proceedings. It is based on trust. Tell me then, what does the bill have to protect arbitration tribunal against government courts? Because these days, arbitration tribunals or trial courts and commercial courts and trial courts, they are working hard to squeeze arbitration centers out of our reality. Well, you know, an arbitration tribunal is not an agency. It can't be engaged. An arbitration tribunal is a panel of arbitrators. You may have one arbitrator or three arbitrators. That is a tribunal. It's not a judicial institution. While your bill is based on the concept of government courts. And you're trying to make arbitration tribunals equal to the government court. By doing so, you're killing the meaning of arbitration proceedings. What can be done to protect arbitration proceedings? What has been done to do so? Thank you very much for a question. That's an extremely appropriate question, and it gives us a chance to tell you what has been done. The first thing that has been done was we made an attempt to make reference to the international conventions which have grounds for the reversal of arbitration awards based on the grounds in the New York Convention. And we took away broad interpretation of reversals. That is what was not done before. And before, the government courts had a lot of discretion in interpreting the awards as broadly as they could and reverse the awards. Number two is legal predictability. Really, how it related to arbitrability, because arbitrability initially was defined very broadly and vaguely, and that resulted in what you appropriately described. When for different reasons, and of course the biggest reason was the government court's lack of trust in alternative dispute resolutions, what government courts did, they closed, destroyed arbitrability for a great deal of private commercial disputes which should be arbitrable by definition. That was another very important segment of what we did. And number three, when we discuss creation of arbitration tribunals, creating a single set of rules, etc., we are not discussing there the format of arbitration center work, because well, we all remember our university years. The court is above all means the judges, but we have permanent institutions, organizations which assist arbitration proceedings and help them function. We have rules, we have the staff, we have standards which create transparent, clear, and confidential arbitration proceedings. As for justice versus non-justice, well, we are at a kind of a dead end, because the Constitutional Court issued a famous ruling interpreted by many of my colleagues as putting an equality mark between arbitration tribunal and government court. Another essential thing, the desired result of our reform, will be creating institutions which will be administering arbitration disputes, the proceedings which the government courts will trust. No matter how we criticize commercial court judgments or trial court judgments, no matter how harshly we criticize them, we must realize that very often pseudo or quasi-arbitration tribunals around, there's a huge number of or amount of fraud led to the government court's antagonistic, negative attitude to arbitration centers. And if we manage to remove such fraudulent centers from the market and maintain good faith arbitration tribunals, many problems will be resolved quite differently then. And there'll be less quarrel with the court's judgments with respect to arbitration tribunals. What has been done to achieve that? Above all, we have introduced a lot of clarity into the conflict of interest, because engaged tribunals, engaged courts, are the courts which get stuck in the conflict of interests. And that is when the strong party in a contract can exert pressure on the arbitration tribunals. I can give you lots of examples of big corporations which own a special arbitration body which they establish to have awards which are good for them. Another issue that should promote trust if resolved appropriately is a new provision we'll be introducing. It has to do with the changes to be introduced in public registers, whether it's a real estate public register or it's shareholders register in corporate disputes. This measure alone, and I'm sure that my colleagues will agree with me, this measure alone will help us get rid of at least 40% of pseudo arbitration tribunals and help us remove them from the market. Let me assure you that We have addressed those issues. We addressed them very hard. And we didn't assume that arbitration is anything but an alternative dispute resolution. It's an independent proceeding, and the parties must have discretion and freedom in deciding where they want to bring the dispute. And the agencies, the tribunals, arbitration tribunals, which decide on the dispute, must have a lot of authority, which we don't want to limit through rules, but to make sure that the arbitrators are.
But we also need to make sure that the requirements of observing the conflict of interest provisions should be there. It's in the interest of the government, the business, and the legal profession. I hope I answered your question. Yes, Vladimir. A couple of comments on that. First, to complement what Elena Borisenko said, we are establishing a 1-month term for the enforcement decision to come into force. So, and that's important for the business community. And the arbitration court would always claim that we need some time to look into the matter, how this or that decision should be enforced. But they wouldn't be asking for a list of documents that are put into the enforcement order, but they would be asking for the full set of documents under a case. But just want to have only check of the principal documents under an enforcement order, no more. Strangely, if you take a look at the existing legislation, the arbitration institution is an institution and a composition, but the arbitration entity would be an arbitration entity, and the arbitration court would be this composition of judges that you were talking about. Somehow the 3 arbiters or 1 arbiter would the idea is that the 3 arbiters or 1 arbiter going into a case should be guided by only one idea as to how to provide an objective and fair review of the case. Just to add, indeed, in principle, you are correct, because there is a difference between a composition of arbitration and an institution of arbitration. But going back to this problem of a pocket arbitration court, you would have like 3 arbiters, 2 chosen by the 2 parties and another one selected by from the outside. But who would be appointing the head jury? So sometimes you can appoint an arbiter. But if you are an institution with an attached arbitration court and the 2 parties cannot really agree on the 3rd arbiter, then you, as the owner of this attached arbitration court, would appoint the 3rd juror, and that's the conflict of interest and a lack of trust to such arbitration procedures. I think we are running out of time now, but I would probably offer a blitz Q&A, a short question and a short answer. Katerina Kudelic, the higher arbitration court, so far it's not the of-profit arbitration court, but the system of arbitration in courts or tribunals was presented as some kind of an outdated system. Somehow, I believe that the arbitration in courts, the public arbitration courts, would not be looking into the substance of the private arbitration court decisions, and the public legal system acts upon its own procedures and the private one under its own. 1 month for the discussion and review of disputes, and before we had 3 months, but still this is the ECHR directive that we do have this requirement for a fast and efficient dispute resolution. But sometimes we actually have too little time to review a case, and we need more time for that. So to have this accelerated and shorter time to get an enforcement order on a case, this is something that many want. About the special courts, I think the special courts are on the enforcement orders for domestic arbitration in courts. This is something that we don't need. The courts are okay with that. And the red flags that you've mentioned here, we all know about them, but it's probably a much more complicated idea to have an enforcement in the case of involving foreign arbitration. Thing is that we don't have many such cases with foreign arbitration involvement, so it's not probably too topical for today, but for tomorrow for sure. Vladimir criticized the fact that the decision was not made to increase the level of courts for arbitration, but there is the right to a court hearing, and the appellate courts, they have different nature and the limited number of reasons and facts and cases to be reviewed. Now, in line with the ongoing court reform, when the High Arbitration Court existed before and was recognized as an efficient institution by the European Court for Human Rights. The Supreme Court, by the way, was not recognized as such an efficient institution. So, removing this one additional tier of the court system for appeals would not be proper. So, this is something to remember. By the way, we actually offered an appeal on that, but an appellate court for that. But again, it was referred to the competence of the first instance courts. I'm prepared for a comment, but you asked us to ask questions. So I should probably say that you remember this famous saying that the fact that you're not detained is not something your advantage, but it's our fault. But the fact that the arbitration courts are not part of the court system, and hence we have all those issues and challenges with the pressure on the arbiters and lack of evidence, etc. This is bad, but the responsibility of the arbitration institutions is a delicate point, and we can have some abuse from the other side. Now, what would the panelists think about this? You know, in the draft law, we actually pay a lot of attention to this, because I think in Andrei's presentation mentioned that in terms of some criminal responsibility, we really did not follow this suggestion of introducing such criminal responsibility and liability to arbiters, because arbiters would not enjoy this immunity, just like the courts of judges of common courts. So we may have some problems with the implementation and enforcement. But I think that we actually have a stronger responsibility of arbiters for assuming fake evidence and abuse. Some civil law responsibility for arbiters. We thought that indeed if we are talking about some falsified information used or accepting falsified evidence, that's where such responsibility can rest with. And dear colleagues, I would like to thank you for this fruitful discussion that we had. At least it was fruitful for me, and I hope that the participants really had a lot to think about, and I'm sure that this discussion is not over because the draft law has not been even introduced into Parliament yet. We are still working on that. And we are still working it internally in the government, but it was also publicly discussed, and the version that was initially introduced by the Ministry of Justice was totally different. And even daily today, we are still perfecting the law internally, and the work would continue also after such a draft law would be introduced into Parliament. We would be very much interested in the opinions and comments and proposals of constructive nature on that draft law, and I would urge all of you to work together with us, because we all started this together, and we all are interested in having a good result so that Russia would become a good country for the arbitration and mediation, for the whole range of alternative dispute resolution, for the whole range of possible resolution methods, because in this case we would see that legal profession would be progressing, and our court and legal systems would be removed from any excessive burden. Thank you to all, and I all wish to you to spend some good time tonight, because the Hermitage would be open for you and the cultural program is available for you. And tomorrow we would meet again as part of the plenary session, and we would be happy to see all of you tonight and tomorrow, and of course in a year's time when we are planning to continue our discussions. And hopefully by that time we would have a new draft law, and we would be discussing this as a finished product draft law. Thank you.